Okay, second application, which is NED2100627FL at Clay Cross. Before we move on, I would like to point out, because there's been a lot of chatter and airtime over this, that we are here to determine the application in front of us, and that is all. It is the amendment. Thank you. Straight over to the planning officer.
Thank you, Chair. Aid, can we have the presentation up, please?
Again, Chair, I thought I was sharing the screen. Is that visible to everyone?
Not as yet.
Not yet.
That's okay, Alan.
That's it, Aid.
Yeah.
Have the first slide, please. Thank you. Right, this is an aerial photograph of the site, which has an extant permission which is currently under construction. Clay Lane lies to the south. To the west is Windermere Road, whose rear gardens abut the Press Brook, which runs next to the western site boundary. The trees on the western site boundary with the brook are covered by a tree preservation order. Can I have the next slide, please? This is the red line site boundary plan, which is relates to the original application. Next slide, please. Thank you. This shows the revised site layout, which seeks minor changes to the road alignment and plot positions in the northwest corner, and also to the affordable units fronting Clay Lane. The site levels are similar to those already approved. Works on site have begun, and the levels in the northwest corner have been raised to the approved levels under the existing permission. The bottom of the plan shows the highlighted wildlife buffer with Pressbrook, which is the same as approved under the original permission. The next slide, please. Thank you. This shows a comparison between the approved layout and the proposed layout. Got the approved layout on the left-hand side and the proposed layout on the right. The proposed layout generally brings units away from the brook and only has 3 gardens directly adjacent rather than the 5 on the extant permission. The western side boundary fence line is the same on both layouts. The affordable units fronting Clay Lane to the south have a slightly revised orientation and garden shape. Yeah, the next slide, please. This is a zoomed in extract of the proposed layout, which plot 20 next to turning head is in the same position on both the section 73 and also the approved layout. Yeah, next slide, please. This slide shows a proposed landscaping scheme with the additional planting alongside the brook and next to the affordable units at plot 21. Proposed landscaping is now consistent with that already approved under the extant permission. Thank you. This plan shows the location and cross sections of a relief tank that has been proposed by the applicant. That's a photo taken within the site, looking towards the northwest corner. The trees along the Press Brook are in the background. So another photo of the northwest corner where plot 11, a bungalow, will be sited. The levels have been raised in accordance with the original permission, and the relief tank would also be sited in this location. This is a view from the northwest corner looking east. The northern site boundary lies to the left of the photo. This is a view looking south towards the turning head and plots 19 and 20. The trees and Press Brook are behind the fence line. It's another photo looking south back towards Clay Lane and the Press Brook. Thank you, Chair.
Thank you. And I believe we have 4 speakers for this application. And the first one is Councillor Ross-Shipman.
Excuse me, Chair, would you like us to bring in the other speakers now?
I think they're already here, Alan. I've got 7 places facing me.
That's marvellous, Chair. Thank you.
Councillor, you have 3 minutes.
Thank you, Chair. I don't see how you can talk about this application without talking about the original one, because the legal advice that's been sought off this new one actually doesn't address the wider problem, and that is that there's a flood risk from the development. And DCC say that they believe there still is, which is why they've also kept their concerns on the record that the committee need to read and understand, because all along throughout this development, residents have been promised that work will be done to mitigate the flood risk, but actually it's been a farce from start to finish because that's never been done. And DCC are now accepting that by not removing that comment off their comments that they've put to this committee. I think that the committee can't pass this application today until those flood risks are dealt with, because it's all well and good saying this change of conditions doesn't alter the risk. But between how the land was originally and this application now, there is an increased flood risk, and that's why County want their hydraulic survey doing on the brook, and that's still not been done. As part of this application, there's the relief tank, which takes, I think, 100 cubic meters. That's nowhere near enough to take the water load that previous floodplain used to hold, and that's why today the planning committee need to actually look at that flood risk aspect, because it is part of this application because they've put the release tank in. Another thing is that the legal advice that the council has sought on this, it doesn't actually say who is responsible should houses on Windermere Road flood. It says that the district council is not responsible, but it doesn't say who actually is at the end of it. And I think until the planning committee know who will be responsible if those houses on Windermere Road flood, how can this be passed? Because we know the county have got it wrong the first time round in the main application. So how can we trust that there is no additional flood risk on this application just because counties say there isn't? And I think that the district council really need to find out who is going to be responsible if those houses on Windermere Road flood. And until that's done, I don't think it can be passed today, I'm afraid.
Are there any questions for Councillor Shipman? No, thank you. Second speaker is Mark Allen. Mr. Allen, you have 3 minutes when you're ready.
In 1994, planning was refused on this site for a single bungalow due to the risk of flooding. Planning Committee report dated the 15th of December 2020, paragraphs 2 to 4 on page 14 state, flooding in the area adjacent to Pressbrook is and always has been a major problem. In line with present conditions, it would seem that flood present guidelines are irrelevant and should be reassessed, and that building on the site will only exacerbate and contribute to the problems already endured by the residents of Windermere Road. Document NED2100627FL dated May 18, 2018. Section 2.3, following comments on the consultation draft plan in 2017, including the Environmental Agency, the site boundary was altered to exclude a strip of land which was in flood zone 3. Section 5.1 DLP on behalf of Woodall Homes state that with careful layout, the site could yield 36 homes, yet the council considered a yield of 25 homes more appropriate, considering the requirements for a buffer zone. Prior to the original planning application being approved on the 19th of May 2020, I submitted video and photographic evidence showing the brook with a water height of 1.26 metres. The LPA failed to take notice of and act upon this. For the revised application, I again submitted video and photographic evidence showing the water height at 1.26 metre. Woodall Homes contacted BSP Consulting to carry out a flood risk assessment of the brook in line with government guidelines, who stated that the peak water height of a 1 in a 100-year episode would be a height of 0.919 metre. This figure has been proven to be inaccurate, as I have submitted on several occasions photographic evidence showing the height 341 mil higher than what the supposedly experts predict would be a 1 in a 100-year episode. That peak height's been exceeded 4 times in the last 2 years, which shows the experts are wrong. Woodall Homes have now raised the embankment on the eastern side of Pressbrook, which I believe will lead to flooding along Windermere Road. Precedence has been set in the case study John Green versus Lord Somerleyton 2003, based on the actual water heights measured compared to the theoretical height given by BSP Consulting. Then I would hold both North East Derbyshire District Council and Woodall Homes jointly liable of corporate negligence, as the evidence was provided prior to building work commencing. The government white paper on planning states that local residents' opinions.
Thank you, Mr. Allen. Are there any questions for Mr. Allen? Mr. Allen, if you want to stay there till, I don't think there are any, so please sit down. Okay. Next speaker is Richard Eden. You have 3 minutes, Mr. Eden, when you're ready.
I will be objecting on behalf of myself and most of the residents of Windermere Road in conjunction to the revised 73 planning application. I spoke in the original application meeting 12 months ago. We gave photographic evidence of the northwest corner in flood. The land acts as a natural floodplain. Our comments were disregarded and quoted as hearsay. We object to the revised planning objection on the grounds that the northwest corner has not been correctly surveyed. The developer has planned to build a tank to take flood water from Pressbrook in heavy rain. The tank will not take the volume of water that the floodplain did. The figures that they have the figures they have worked from are incorrect and therefore puts further risk of flood to the existing residents. The new layout will also impede on the wildlife buffer zone that was agreed and affect trees in the TPO. The LFA are not happy with the figures and has advised the developer to complete a topogeological hydraulic survey, which the developer has chosen not to do so. I have watched this section of land from childhood slowly decrease in height due to continued increasing and decreasing of the water table to become a natural floodplain and become our safety net in heavy rainfall. The now raised land will not stop the water table rising and decreasing. The houses will be built on concrete piles, but their gardens and driveways won't. This raised land gives the potential for sinkholes to appear in time and mudslides into Pressbrook. We have now proved that the land was lower than ours and was a floodplain and is in flood zone 3. We are now at further flood risk. The LLFA have objected to the original plan. The EA advised back in March that a topogeological hydraulic survey needs to be completed if there were any concerns about flooding. This has not been completed. The LPA legal document clarifies it has put us at further risk of flooding and that the developer has misled the LPA and the LLFA, stating the land was higher than Windermere Road. We have no faith in the developer who has misled, had to put in another revised application because the Holmgate sewer was not where they thought it was. completed a flood risk survey on figures that are not correct, which has been proven by the LLFA. I believe the only way to rectify this is to put a hold on this application until the correct hydraulic survey is completed. I would also like to know what mitigation action do the LPA plan now that they know we're at further risk of flooding due to the development, and why MPPF legislation on flood risk was not adhered to.
Thank you. Are there any questions? Thank you, Mr. Eden. If you'd like to take a seat.
Thank you.
Our final speaker on this application is Simon Betts, I believe is the agent. Three minutes, Mr. Betts, when you're ready.
Chair, members of the Planning Committee, thank you for the opportunity to speak. On behalf of the applicant, I wish to make the following observations. Firstly, I would like to reiterate and add to some of the key elements from the committee report, which comprise essential context in informing a decision on this application. Namely, this site is allocated for housing within the newly adopted local plan and is therefore part of the council's committed housing and supply position. This site already has the benefits of a full planning permission for 34 dwellings, with all pre-commencement conditions having already been fully discharged and a lawful commencement of development having already taken place. The process for minor material amendments exists to account for changes as a result of the detailed design process and/or site conditions experienced. In this case, in the applicant seeking to implement the planning permission they already have, it relates to the on-the-ground location of a sewer being different to the asset plans provided by the statutory undertaker. This generates the need for minor revisions to the internal road layout and some of the plot positions, hence the application before you today. As such, I would respectfully comment that in the case of this application, it is essential that members understand the terms on which they can make a decision and the issues which are relevant and those which are not. Whilst it is noted that the application has generated concerns in relation to flood risk, the minor revisions for which permission is sought do not introduce any material concerns in relation to flood risk, and all of these works that are subject to this application are within flood zone 1, the lowest risk area. As confirmed by the council's own legal advisors, this issue cannot be given any material weight in the consideration of this application, and to do so would, I quote, be perverse. In saying that, in a response to the issues raised in the discussion today, I will clarify that the applicant has positively responded to the concerns of the LLFA throughout and is happy to continue those discussions outside of this process. As such, I would urge members to carefully consider the terms of this application, the facts before you, and the legal advice received by the council, and will welcome support of the officer recommendation to grant planning permission.
Thank you. Are there any questions? No, thank you very much. Are there any questions for the planning officer? Councillor Hancock, Councillor Elliott.
Thank you, Chair. I am actually going to refer to the flooding issues because it is referred to in the report quite significantly. I mean, several pages are dedicated to this. It does tell us, and I've got no reason to doubt it, that both our planning officers and the LLFA suggest that there's no further risk. The key thing which occurs to me is in 720, whereas it says as matters have progressed, it has become apparent that the developer's representation was incorrect. So what you're telling us on one hand is that there's no further risk, but the risk assessment is done on information which was incorrect. Now, in my head, those two things don't tie up, so I don't see how we can legitimately give a decision either for or against when we're being given contradictory information in a report and we're being told that a previous decision has been made on information which is not right. So particularly I'd appreciate Jim, I think more than anyone, giving us guidance on that, because to me that would be negligent on our part.
Yeah, I think what members need to look at here is the what is the application in front of you. The application in front of you is to make a minor material amendment to the road layout. So the question you need to ask is, what additional effect does that material amendment have on the flooding issue? I understand that there are concerns about what's happened on the previous application. However, that has now gone. You've approved that application. So the issue here is quite simply, does what is proposed have any additional effect on the flooding issue? And I think the question or officer's belief is that no, it doesn't. It doesn't have any impact whatsoever on the flooding as it stands, and therefore it would be inappropriate for you to take into account any the flooding considerations that took place before. So what you have now is a situation where there is no the proposal doesn't have any impact or any additional impact on flooding, and that's the issue that you need to consider.
Thank you. You happy with that?
I just reply.
Yes.
Yeah, because again, I'm not really getting clarity here because I mean, one gentleman, I'm not going to make the same accusation because I don't know, and I wasn't on the planning committee when this was originally heard. But the term misled has been used. Our own report from our officers says that information was incorrect. So we're being asked to make a decision based on something that we are being told was wrong. So that's my concern. It's a case that we're being said that we're assessing something against something which is incorrect. That's our terminology. To me, that the two things just can't, we can't give a legitimate decision when we know that something's wrong. I'm not arguing for or against because we haven't got the right information to argue for or against. And that's so what you're saying is we've made a decision, even though we're now told that decision was wrong. We're assessing against a decision that we know to be wrong. That's not making sense, Jim. So again, where do we stand on that position? Because what you've said to me doesn't make sense. What
you need to do is set aside the original decision. That's already happened. That is now a lawful planning permission. So you're looking at a very limited or very narrow remit here, and that is whether what is proposed is acceptable, and does that have any additional impact on the flooding situation? And the question or the answer to that is quite clearly no, it doesn't have any impact on flooding.
Chair, if I may just add to that as well, please. In terms of the decision that was taken on the original application, that was taken on the advice that we had at the time from the local flood authority. So to say that decision was taken incorrectly, Chair, in my view, is not correct. It was properly taken based on the expert evidence and information that the council had at the time, and which was offered to members by officers on the basis of the information that we had at that time, and following proper consideration and consultation with the experts. The issue that is before members this morning, Chair, is, as Jim says, and as is stated within the officer report, that the LLFA have accepted a note that this Section 73 application has no increase in terms of flooding impact over and above that which has already been granted. And therefore, Chair, as set out in our report to members and in the legal advice, you are properly to afford no weight to any objection or comment that the LLFA have at this stage on that issue. And that is that's the basis of our recommendation to members, Chair.
Thank you.
Just for clarity, Chair, and to pick up on Adrian's point, the word incorrect is what is used in the officer report on page 46. It's not a word I'm applying. So just for clarity, because Adrian is kind of implying that I'm using the term incorrect. I'm using it from their own report.
Thank you. Councillor Elliott.
Thank you, Chair. Adrian, if you could just indulge me, I'm not comfortable with the flood part of it. and I accept what you've explained is right, that, you know, this part of the application is nothing to do with that. It's just, but it's like stripping out one tiny piece of information from the whole application. And I'm not desperately comfortable with making any decision on it. I read in 725, and this must be down to the timelines it was done, but it says the LLFA considered the current hydraulic assessment and flood compensation proposals aren't satisfactory enough, given the sufficient confidence that flood risk isn't increased. Can you just run me through that to set in my mind? Because, as I say, you can strip one piece of information out and we're not dealing with the flood on this part of the application. That's what worries me.
If I interpret the question correctly, Chair, hopefully I'll help Councillor Elliott. If not, I'll ask Councillor Elliott to come back for clarification as necessary. But as I've just explained, Chair, the basis of the original application that was considered by members and approved was based on the expert evidence that we had at that time. The expert evidence we received from the LLFA was that there was no objection to the application. Subsequent information has impacted on that original consideration, and the LLFA have the concerns which the applicant has sought where they believed appropriate to provide additional information, etc. And that has resulted in their offer of the tank that Phil explained to you earlier is proposed now by the applicant as an addition to seek to in part address the concerns that the LLFA raised. However, in terms of the information that we could properly ask for, the advice that we have is that if there is no evidence that the current scheme is going to impact on flooding any more than the original, and we've been advised by the LLFA themselves that is the case, there is actually no need to provide additional information to support that, because there's no increased risk. And as Jim's advised, that permission that's granted is extant and can be implemented. So that's the basis of the LLFA's comments, as I understand them. They would like more information. The applicant has said, well, we provided this information. We actually don't need to provide you with any. Therefore, whilst you would like this additional information, there's no requirement on us to provide it. So we provided what we think is appropriate. So that's the situation that we have. In terms of the final outcome of this, we have as officers sought clarification on that point from the LLFA, and that's set out in their comments, which we've underlined for emphasis on page 35, that there is no greater impact of this development on that previously approved. And therefore, on that basis, whilst offering comment, there is no basis for us as officers to say to you as members in making your decision that you should place any weight on the concerns raised at this point by the LLFA, even though they may have concerns about the issue of the Pressbrook and how it reacts to flood events. I hope that's helpful, Chair, in setting out, Councillor Elliott, the timelines as I understand them.
Thanks, Adrian. That's exactly what I wanted explaining, and I understand you can't give us any more information on it. It just seems that, you know, with the information given, I'm struggling to make a decision on it, but we are supposed to ignore it, basically. That's what you're saying.
The advice that we have, Chair, is that, yes, there should be no weight placed on any objection raised at this point by the lead local flood authority in view of the comments that they expressed on the outline application based on the information to at that time.
Thanks, Adrian.
Councillor Armitage.
Yeah, thank you, Chair. It strikes me that all the way along with this first planning application and what we're asked to do now, the information that we've been given has been flawed. And, you know, the LFA have admitted this, and we voted on this to pass it because there was, they said there was no problem with the flooding. And if we look at the actual problem with the flooding, it's because there's no, would you agree, there's no management of Smithy Brook or Pressbrook. That actual brook drains thousands of acres from above. And if it was dug deep, or cleaned out to start with, instead of all the trees, we wouldn't be here looking about flooding problems. It should have been drained. It should have been done properly to the correct spec. And no one seems to be wanting to have anything to do with this brook. And, you know, we're going to put this, would you agree, that we're putting this flood tank in? And as far as I can see, yeah, it's all right, put it in. But we've had some pretty heavy downpours, and we've been predicted we're going to get more. And is the tank big enough? I mean, how big would it need to be to stop this flooding problems on the site? They pulled all the trees out, which allows them to the water to percolate slowly. I mean, they were all pulled out and burnt on site. And as far as I can see, this flood tank won't make much difference at all, because it will just fill up. And theoretically, would I be right in saying it's due to empty at a slower rate, but it's still going to put water down into Smithy Brook, which is already congested with fallen trees and God knows what. When it should, in the first application, have been cleaned out completely and deepened to stop any flood risk. Would you agree?
I'm presuming, Chair, that Councillor Armitage has directed his questions at me. I'll assist as I can, Chair. The maintenance of Pressbrook is a matter for the management of those who have responsibility for Pressbrook, Chair, and that's not something that we as local plan responsibility for, nor do I believe the council has responsibility. It may well rest with the LLFA or any riparian owners that there are. In terms of the tank, it is designed to ameliorate any impact of flooding that there may be during the Pressbrook, any potential loss of flood alleviation that the site may have otherwise provided, Chair. The advice we have is that it will make a difference. I'm not a hydrologist, so I can't give chapter and verse on that. But to my mind, the provision of tank storage must have some positive impact on how flood water would be managed as it comes down Pressbrook, because it provides some storage that isn't there at the moment. So that would be my view on that. But I'm not a hydrologist. We have reacted at all stages, Chair, to the expert advice we received from the LLFA, the Environment Agency and others. And as officers, we presented that information in good faith to members on which you base your decision.
I'd like to just draw your attention to on page 35, 4.14. Any DDC engineers have not commented. I mean, surely, after all the flawed information that we were given in the first instance, it should have been, the engineers should have commented, at least said something.
Again, Chair, we will have consulted the relevant bodies and sought their advice. As we haven't received anything, we've reported that in good faith to members, Chair. The primary consultee on this, the LLFA, did comment on the original application. As I've said, we presented that information, their comments and their no objection to the application in good faith to members. As Jim explained earlier on, Chair, that is the background to this application. That's an extant position. And in respect of the current application, as it presents no greater impact on flooding than that which has already been approved, and that is the basis of the evidence that we presented to members, which is backed up by the expert legal advice, Chair, that we've received on that basis. And that's on that basis, that's the way that we've set out our report to members in advising you on this application.
Thank you. Are there any further questions? Thank you, Adrian. I'll open the floor for debate. Councillor Liggett.
must admit, I'm very perturbed because I was involved with a similar application in my own ward. A floodplain was built on. We were assured that things were put into, it was a pond this time, not a tank, but it was supposedly to be the water to be allowed to flow out, heavy rainfall to catch the water, and it to be allowed to flow out to slower rate. The minute they took the topsoil off, we were flooded. And now the development is nearly finished. About 6 weeks ago, we had that very, very heavy rain on the Sunday. Our neighbours were flooded. They were away on holiday. I followed the course back onto the development, and there was nothing in that pond. So it wasn't holding anything. It was just going straight through, as it always had, only twice as fast. So I'm very concerned that that won't work. That's my worry. I know we're not supposed to be talking about flooding, etc., but I think it is relevant.
Any further comment? Councillor Hancock, then Councillor Barker.
Thank you, Chair. I agree with everything Heather's saying here. I totally respect what the officers are saying, and I know what Adrian says is 100% correct, that they give us the information in good faith. And the reality is, when the previous when it came before planning before, that information was also given in good faith. The problem is that information has been proved to be wrong. The legal advice, which is stated in 7.27, is less clear than is being presented to us, because it does say that weight is a matter entirely for the decision maker, and that provided the decision maker properly takes into account all relevant matters and does not take account of irrelevant matters, no court will interfere with any decision. Well, the reality is it is a relevant matter, because we wouldn't have spent 5 pages of this report discussing it. Yes, we're being told there's no greater flood risk than there was previously, but the LLFA are actually basing that on the fact that, or appear to with the way it's worded in here, based on the fact that they have raised concerns, and those concerns were not taken into account because they weren't present when that decision was made. My honest opinion is, I can't go with this recommendation. I don't think there's enough evidence for us to go against it, but I do think we've got to defer and have proper reports in front of us so that we can make a proper informed decision. So yeah, I can't comment any further than that, because there's not enough for us to go on, Chair.
There's lots of comments about reports, etc. So I'd like people to actually consider page 47, 7.27, and it goes on about the flood risk, and the bottom part of it is, further, it is advised that in the event that the LLFA cannot identify how and to what extent the Section 73 application increases the risk of flooding over and above that which already exists, arising from the permissions already granted, the decision maker can and should place no weight on any objection made by the LFFA. Council reminds the council that weight is the matter entirely for the decision maker, and that provided that the decision maker properly takes into account all relevant matters and does not take account of irrelevant matters, no court will interfere with any decision as to the weight given to a particular matter unless there has been perversity. However, to give weight to an objection which is irrelevant to the works being proposed would be perverse. And I think that's something we really need to consider, because this application is an amendment. And I shared people's issues about flooding, but that is not what is before us today. Thank you. Oh, Councillor Barker, sorry if I preempted you. Apologies.
It's all right now. Well, that your rounding up speech. Sorry.
No, that was me having my say.
That's all right. It is difficult, isn't it, this one? I'm struggling with it, same as one or two have already said. And I wasn't involved in the original decision. I know it's been controversial, and I know we're looking at the minor amendments because it's already been approved. But having read the report and listened to what folks have got to say and other councillors, I'm struggling to put my name to it, because if in the future there's flooding on this site for the new houses or on Windermere Road, I'd feel guilty about that. So I tend to support what Councillor Hancock said. There is a lot of stuff in here that's just vague. I mean, there's a lot of them initials, LLFA and all that are not happy with it. And I accept what you've just said, Diane, you know, that paragraph does make it clear we're only considering this, but I'm still struggling to put my name to that because I've just come to it today. So that's where I am. And if there is a compromise somewhere along the line, like Councillor Hancock just said, then I'll consider that. So I'm still undecided what way to vote, to be honest.
Okay, are there any further comments? Councillor Powell?
We're faced with a very difficult set of circumstances, aren't we? But I have to say that we have no choice. What is actually before us is not controversial. Everything that's gone before has been, but we've got to just look at, as this committee's responsibility is to not consider what's happened in the past, but only to consider what's happening now. And as we have been told more than once, it makes no material difference or no additional risk. It's unfortunate, but as I say, I don't think we have any choice. Thank you, Chair.
Thank you. Any other comment? I'll put it over to a motion. Anyone want to propose one?
Excuse me, Chair, just before you do that, would it be helpful if I just reminded members about the arrangements as regard motions?
Yes, thank you, Alan.
Okay, thank you, Chair. Please bear in mind, members, that a motion must be moved and seconded before a vote is taken. If an amendment to a motion is moved and seconded, then that amendment will be voted on first. If a motion is to be moved which goes against officer recommendations, then the member who has moved the motion must give the reasons for doing so. The reasons for moving a motion against officer recommendations should comprise the relevant planning issues and be supported by the evidence as necessary. If a motion to reject officer recommendations falls, or in other words, it is not passed, that doesn't mean that the recommendations are automatically approved. Rather, you will need to take a positive decision through a further motion in favour of the recommendations or another course of action. This will need to be approved by the committee through another vote. Thank you, Chair.
Thank you. Well, I will actually support the officer's recommendation, and that is my motion. Put forward that we vote on that.
I'll second that, Chair.
Thank you. And I will have a roll call. Thank you.
Thank you, Chair. Members, if you kindly indicate for, against or abstain. Councillor Armitage.
Against.
Councillor Barker. Councillor Clough.
Abstain.
Councillor Cooper.
Abstain.
Councillor Elliott.
Abstain.
Councillor Hancock.
Against.
Councillor Hartshorn.
Abstain.
Councillor Liggett.
Abstain.
Councillor Powell. Councillor Rouse.
Against.
And Councillor Ruff. So, Chair, with 2 votes for, 3 against and 6 abstentions, the motion falls.
Councillor Hancock?
Chair, can I move that we defer while we have proper, so that we can have proper information to make a decision on in the future? Because what we have got, it's telling us there's no greater flood risk, but we genuinely don't know what the flood risk is. And I think we do need to have that information to make a proper decision. So that's my motion to council, if someone's happy to second that.
Councillor Armitage has just seconded. Those
Chair, if I may, just before members take a vote on that, if members were minded to defer the application, then we would need to be given clear advice as officers what the deferral was based on and what additional information you are looking for. because we would need to be specific in respect of any request. We go back to the applicant on for that information. And I just asked members to recall what I said earlier on, that the applicant has responded to a certain level of additional information being provided, but they've taken a view that they have provided more than they believe is necessary, and have sought to, on the basis of that, provide the tank that's part of the consideration that's before you. Also, Chair, in terms of the advice that we've been given, again, ask members to note that, and the allowance that we have for seeking additional advice, bearing in mind the LLFA have themselves said that the proposal before you is not going to increase the level of flooding over and above what is extant and can be constructed. So if members are minded to defer the application, we need to be very clear what additional information is given, and then we would seek that from the applicant and await any response. Thank you, Chair.
Councillor Hancock.
Thank you, Chair. For clarification from my perspective, and obviously it will be up to Councillor Armitage if he's happy seconding that, the information that we have is not consistent. We're asking for consistency. The LLFA are saying that there is no further based on what they're saying, but that's not actually consistent with the previous extant permission. It's that what we've got just is a mess. And we've been put in a catch-22 situation of being asked to approve something that we've been told the original information is incorrect. We need correct information. We're giving a decision based on facts. We haven't got facts. So we need clarity in order to put a proper discussion forward. And to be perfectly honest, I'd like it minuted that officers shouldn't be putting us in this position, whether that's our officers or other people's. So that hopefully gives the clarity we need to know what the flood risk is, because it's being referred to in this report. We're not introducing it from nowhere, but we're being told to compare to information which it explicitly says is incorrect. So we want correct information, please.
Does that information take us back to the original application in Adrian? Because that's not what's before us, because historically it's been passed.
Yes, Chair, I'm not seeking to put members in a difficult position, and my apologies if it's taken that way. All I'm seeking to ascertain from members is if the committee is minded to defer the application, what other information members are seeking, and I'm also trying to frame that on the basis of the advice that we have from legal colleagues and from the information that we've already received from the applicant. I can see that Richard's got his hand up as well, Chair. He might be able to add something further to what I've just said.
Okay. Who had, sorry, Adrian, who had their hand up? Richard. Oh, sorry, Richard.
Thank you.
Oh, I can see you now.
Thank you. Yeah, I'd just to sort of add to what Adrian has said there, that clearly if there is a request for some additional information, then that information must be appropriate for this particular type of application, not information that should have been required previously last year when the last application was determined. And that is what's I think that there is an absence from the debate that I've heard so far, that the request for information isn't information that is relative to this current application. It is only relevant to the application that we have previously had. Now, I don't particularly want at this point in time to go back to that application, because I think we need to concentrate on what this particular application is about. And just to say that, yeah, it is quite clear from the legal advice that has been received what the scope of this type of application is. And I think that everyone around the screen, everyone in the room would have some empathy for the situation that we have here and understands the issue of flood risk. However, the legal framework for this type of application does not allow this issue to be given weight, because there is no difference between this issue, between this application on this issue and the approved one. And to make a positive decision in relation to this application isn't to throw away empathy or sympathy that decision makers, that councillors, that officers have in relation to this. It is to recognise the fact that this is not something that can be taken on board as part of this application.
Thank you. Councillor Hancock, do you want to be more specific on what you'd require?
I'm not sure that I can be any more specific. I mean, ultimately, we're faced with an application here that has got information that is different to what was put before council previously, and we've got conflicting information in it. The LLFA are giving us one course of advice, saying that it's not an increased flood risk, but they've got concerns over it. So it's there. So we need, whether we need clarification from them, whether we need this report, I don't know really. That's for officers to determine. What they're doing here, though, is saying that there's no greater risk, but we're not sure what we're comparing to. So with respect to Richard, this is the report that your team has given us. Your team have given us contradictory information. We cannot make a decision on this, in my opinion. We've already voted down to follow your recommendations. We're saying we haven't got enough information to actually put a counter to it, to reject it. We need something to go on, and we haven't got it here.
Councillor Armitage?
I'd just like to add this point. We're voting today on a tank, which is supposed to be stopping all the flooding that's going on. Now, this tank will ultimately drain at a lower rate into the brook. And that's the problem. It's going to drain into the brook. The tank's going to drain into the brook, which will cause more flooding. And that's my point. It's nothing, we're voting on this tank, which is supposed to be stopping all this flood risk, but it's just going to exacerbate the whole problem, because it's going into Press Brook, which is already choked and should have been cleaned out in the first place. And that's my point.
Can I respond to that, Chair?
Yes, certainly.
Just to clarify, to go back to to the start of the officer presentation, as to what this application is about. It is about the alterations to the layout of the site and positioning of houses. That's the reason why the application has come in. The applicants have added this tank really as a gesture of goodwill to what this application, to open above what the application is about. And that, whether that tank is big enough to solve a problem that members perceive as existing is the side issue to what this application is really about.
But it's on the table as part of the application, this tank. So it's got to be considered.
Yeah. Well, I hear what you're saying and the reason why, but as I say, they've added that tank to address an issue that has been raised, not because they have needed to do that as part of the application that they want to see approved. And so I think it would be a bit disingenuous to hold the tank against them when it is something that they have added in as almost like a goodwill gesture to the concerns that have been raised during the course of the application.
Yes, they've obviously taken note of what's been said and what's been happening on site with the ripping out of all the trees and undergrowth, which would have sufficed to slow the flow down. And they're going to put this tank in to try and alleviate the problem, but the tank's going to run in and cause more problems because it will go in at a faster rate than it would have done if it had been percolating through the trees and everything.
If I could just come in there, Chair. Councillor Armitage, the tank's taking the water from the brook, not Firstly, that's the purpose of it.
No. Councillor Hancock.
Thank you, Chair. I mean, to return to what Richard was saying, which I do fully agree with, I think we are perhaps sidetracking a little bit because of the tank. The application that's in front of us is to vary the design. The problem that we have, or that I'm perceiving, is we don't know the impact, whether it's got an impact on the flooding or not, because we are explicitly told in this report that the previous representation was incorrect. So on that basis, and that basis alone, is why I'm saying it should be deferred, because we've got an application to vary something, but we're varying it from something that we don't know what the impact was to begin with, because it was incorrect. So that is why the motion is on the table, to actually defer, so we can have proper information and come back with a proper decision, whichever way that is.
I think we're going round and round in circles here. So can we move this? David has put in a motion to defer. Councillor Armitage has seconded it.
So just to be clear, Chair, it's to defer on the basis that before they can take a decision to vary the application, members will need additional information as to what the flooding impact of the variation would be. Is that the essence of it? Sorry, Councillor Hancock, I can't hear you.
Apologies, I'll not put my microphone on, Alan. No, it's to clarify what the flooding risk is, because we're told in the report that the previous data was incorrect. Well, knowing that it's incorrect, we can't then make a decision as to whether there's an increased flooding risk from this or not.
Okay.
So we thought that's irrelevant because it has been passed, but to draw this to a close, I think we just need to have a vote on this deferment. So I'm going to ask for a roll call.
Thank you, Chair. As before, if you could kindly just say for, against or abstain. Councillor Armitage.
For.
Councillor Barker. Councillor Clough.
For.
Councillor Cooper.
For.
Councillor Elliott.
Abstain.
Councillor Hancock.
For.
Councillor Hartshorn.
Abstain.
Councillor Liggett.
Abstain.
Councillor Powell. Councillor Rouse.
For.
Councillor Rough.
Against.
6 votes for, 2 against, with 3 abstentions. The motion is carried to defer.